Hello and welcome to the final lecture on the three certainties. This week we're going to be looking at certainty of objects, although to be honest I often find the phrase certainty of objects to be a bit of a misnomer, because we're not talking about the physical objects that make up the trust, but rather the people who are the beneficiaries. So rather than certainty of objects, it's more certainty of the actual people who will be receiving the benefit from the trust property. Now that that's cleared up, let's get started by looking at some of the different types of trust. The first type of trust that we're going to look at is very simple indeed. These are fixed trusts, and I've just put a simple example up on the screen there. So £10,000 distributed equally between my two children, Ashraf and Shivani. In this type of situation, it's very clear who the beneficiaries are because they might be named or can be specifically defined. On the other hand, fiduciary mere powers are a little bit more complicated, so let's have a look at these. Now, these give the trustee a power, but there's no obligation to actually use that power. Now, as Vice-Chancellor McGarry pointed out in Hayes Settlement Trust, this isn't an excuse to do nothing at all, because the trustee is still going to have to justify their actions and potentially have to justify them before court. So how do we look at certainty of objects in relation to fiduciary mere powers? Well, we have the is or is not test that was developed by Lord Reid in Regal Benkian 1968. And basically the is or is not test says that we should be able to go around potentially every single person in the world, although that's probably not going to happen, and say, are you or are you not a member of this specific class of people? So to give you an example, if we thought about a trust that's for the benefit of members of the UK Labour Party. Now, in theory, you should be able to go around every single person in the world, and if they have a membership card of the UK Labour Party, then we can identify them as a beneficiary of that trust. However, the problem with this test is that it potentially fails the entire trust if there is uncertainty about one single person in the world. So if we look at a different example, so say if I asked you to think about who are your friends. Now, when you start thinking about this, there are probably some people who spring to mind who you think, yes, those people are definitely my friends, and I can say that for certain. On the other hand, there are probably some people who you don't like very much, and you would say, no, they're definitely not my friends. However, between those two classes of people, there's probably a handful of people in the middle who you think, well, I don't dislike that person, but I'm not quite sure I'd go so far as to call them a friend. And so that uncertainty about that small handful of people in the middle means that the entire trust instrument could potentially fail, or will fail, because of those few people. So a way of getting around this was potentially developed by Lord Brown Wilkinson in Re Barlow 1979, and this was to see the trust instrument as a series of identical individual gifts. However, this isn't really a true representation of what a trust instrument actually is, and there's also some questions about what about a justified and legitimate beneficiary who comes along later on and should be entitled to that identical individual gift that everybody else got earlier on. Moving on, we can look at discretionary trusts, and these are a bit of a misnomer because they're not exactly discretionary. They actually require the trustee to exercise their power, as opposed to fiduciary mere powers where there is no such obligation, as we saw. So again, we can apply the is or is not test, and the case of MacPhail and Dalton basically brought that is or is not test from Regal Benkian and fiduciary mere powers and translated it so they said that they could use exactly the same test in relation to discretionary trusts. However, bringing this across to discretionary trusts also brings across the same problems. In other words, what about those handful of people where there is uncertainty? And that potential or drastic application of the rule that would mean the entire trust would fail because of those handful of people. Well, the courts in relation to discretionary trusts have also had a go at resolving this issue. and have probably actually got the closest to doing so. In particular, the case of Rebard and number 2 from 1973. A couple of the justices gave quite different approaches, but both of them are sort of certainly worth taking seriously. So Lord Justice Sachs said, well, it should be the onus should actually be on the apparent beneficiary to prove that they are a member of that set class. So a person who is trying to prove that they are your friend may say, oh, well, we went for dinner twice a week, every week. I also went to his latest birthday party, different things like that to try and prove that they are your friend. Lord Justice McGaw said that the trust can still be valid even if it has minor uncertainties. In other words, if you're able to say for 99% of people that they either are your friend or they're not your friend, and it's only 1% of people who you're sort of not sure about, that's not really a good enough reason to fail the entire trust. And so it kind of picks up a little bit on what Lord Brown Wilkinson was saying in Re Barlow, but develops it a little bit further and goes in a slightly different direction with it. It's a bit more of a practical approach. Moving on, we can look at personal powers, but the holder of a personal power is not subject to a fiduciary duty, and because they're not subject to a fiduciary duty, it means that we cannot invalidate a personal power on the basis of uncertainty of objects. It just grants the person the power to actually use their discretion, and so we don't have to apply any sort of strict rules or anything like that. The person can just choose who they want to benefit. Now, we talked about a few different grey areas, and there's a few common ones that come up in court cases, and as a result they also tend to come up in exam questions as well. So it's good always to have a few different cases at your fingertips to use if you do see these key words. So we've already talked about how friends can be a bit of a grey area, and it's generally seen as being uncertain, and we can look at the case of Brown and Gould 1972 as a good example of that. But we already talked a little bit earlier about how Rebard and number 2 helps to sort of resolve what is going on with that word, and saying that maybe the entire trust instrument shouldn't fail simply because of the handful of people where that uncertainty does lie. Customers is held to be uncertain, that's from the case of Sparfax and Dommett 1972. And when we're looking at relatives, this is certain because we can look at the statute law and look at who your next of kin is. So relatives is quite an easy one to deal with. We can go back to MacPhail and Dalton, a case that we've already mentioned. Now, what about resolving this uncertainty? It may often be in a problem question or an exam question that there is uncertainty, and most of those types of questions will have some degree of uncertainty in them. But you might want to think about ways that the court or the trustees might go about resolving that uncertainty. One way to do so is to use experts. So in Re Tuck Settlement Trust, the question was, who counts as being of Jewish blood? And the courts didn't really know how to resolve this. The trustee wasn't sure how to resolve this, and so rather than giving up or letting the trust instrument fail, they consulted an expert in the form of a rabbi, who obviously does have a good idea about who is and who isn't of Jewish blood. So that's definitely one way to go about it. Secondly, we need to perhaps have rules that set out how to define beneficiaries. So we talked about how friends is a little bit uncertain and can be vague in respect of certain people. But what about if we defined friends as people who attended my last birthday party? Well, that's a clear set of people, and that's a rule that can be applied in a sensible fashion, and is perhaps a bit more certain than simply using the term friends. Also, and finally, in terms of resolving uncertainty, it may appear that a trust that, for example, could apply to everyone in the UK would simply be too wide to be workable. And in most situations like that, the courts would say, well, this trust instrument is going to fail because it simply cannot be administered. However, if it is administratively workable, then the courts will not strike it down. So if you think about members of the UK Labour Party, now potentially if we were applying the is or is not test, then that means that we would have to maybe go around everyone in the UK or everyone in the entire world to check who is and who isn't a member. But if there is a central database that we can work off, then that means we don't have to go around knocking on everyone's door to find out if they're a member of the Labour Party. We could instead consult that database just to make it administratively and practically workable. Now, finally, before we finish, it's worth looking at what happens when there's a partial failure. So we saw about the is or is not test in Regal-Benkian, and we said that generally where a trust partially fails because of, say, uncertainty about that 1% of people, then this causes the entire trust to fail. But something that we've kind of hinted at and talked about throughout this lecture is that the courts are going to be very unlikely to try and do this. They're always going to try and help make a trust instrument work. And that was backed up by Justice Harman in Riga-Stetner, 1953. It may also be the case, as we talked about in Re-Barden No. 2, and as we see here in Re-Leak 1969, that it's possible to remove the uncertain clause of an instrument just to ensure that the entire trust instrument isn't going to fail because of this partial uncertainty. And there we have certainty of objects. Remember, if this does come from a problem question, it's likely that there are going to be some beneficiaries who are clearly identified and some beneficiaries where it's a little bit more vague. And this is where you're going to pick up most of your marks. You can always say that the courts are always going to try and do their best to validate a trust, even when there is some uncertainty. They may just remove that individual provision. Remember, your aim is to try and apply the correct test for the right type of trust, and then to mention some of those key cases like Regal-Benkian and Re-Barden No. 2, and show that you understand the principles that were developed in those cases. Well, thank you very much for watching. If you enjoyed the video, remember to give it a like. Any questions, then leave those in the comments below. And remember also to subscribe for more videos in the future. Thanks very much for watching. Bye!